And welcome to this latest webinar or / podcast. It is really up to you how you consume it, of course. But the one thing which is true is it's a regular deep dive, and I'm going to say it, the authoritative deep dive into strata issues and management rights. Well, it is, let's face it.
No, you're right.
In Queensland. So my name is Chris Irons, and I am Director of Strata Solve. That's stratasolve.com.au. And alongside me, got our position swapped around today, Frank Higginson, partner at Hines Legal, which is premier provider of legal services for the strata sector and management rights in Queensland. Hello, Frank.
Hello, Chris. Hello, everyone. Yet again. And I suppose you're right, mate. It is authoritative because despite the fact we've been doing these for nearly 3 years, no one else is copying us yet.
I get it quoted back to me ceaselessly. These webinars ceaselessly.
Oh,
A number of times I meet people and they say, I saw you and I heard, and yeah, it's definitely there. Just a bit of housekeeping as per always. You can post your questions online and try and get to those where we can, of course. For those of you who are listening in later, say you're out walking the dog or doing the dishes, you can find all of the notes and links we refer to at www.hineslegal.com.au. With that, Frank, this time around, one of the recurring issues in Strata, water ingress.
Yes. So we keep having these La Nina things.
Isn't it?
Yeah, it is. It is. And I mean, this is a genuine, you wouldn't say specifically requested viewer topic, but just by virtue of all of the inquiry we get relating to it, it's worth covering off some of the basics, I think. And the difficulty with this is you'd think a lot of the answers are going to be simple, and a couple of them are, but there's a bucket load of them that aren't. So I think if you've got water affecting you in any way, shape, or form, be that your lot or be on as a committee member dealing with issues in your body corporate, there's probably some basics in this that might help you, but there's really no carve out sometimes for proper legal advice, and we'll explain why as we go through this, because it's just never simple.
I think that's a really good point, Frank. I like you, I get asked about water ingress as a general issue all the time, and I think people definitely want to go right to what's the answer? What's the fix here? Just tell me. I want to know. It's not that simple. It's really not that simple. I'm going to try and expand upon why it's not that simple, but and maybe just give a little bit of a framework as to how you navigate your way through it. But your point, absolutely well made, Frank. But those issues about responsibility invariably will find their way to requiring legal advice because the amount of money involved when it comes to water ingress is often huge, isn't it, Frank?
Absolutely. And mate, I suppose, I mean, it's been quite a few years since you were commissioner now, but back in your day, this still would have been a common query of people coming in, wouldn't it?
Yeah, it is. It is, Frank. And depending upon when you are listening and watching this, whether it's wet season, seems like every season is a wet season these days. Seriously, look at how things have been in Brisbane this year. You put it this way, it's something which really comes to forefront of mind if there's been a particular weather event yesterday, or there's going to be one next week. For those of us who are watching in particularly exposed parts of Queensland, up north, with Sundays, central Queensland, even places like Bundaberg, I guess, and then places along the Brisbane River in particular. I think water ingress is a huge topic. All right, let's stop babbling. Except to say, Frank, we have so much content on this one, we might have to hold over for a sequel. Yeah. So
our usual fly by the seat of our pants and see what we get through, and then save the rest for later.
Absolutely, but I think I like what you said there at the start, Frank. This is a reiteration of some basics a lot of the time, but it's a topic that really benefits from a reiteration of basics. Let's rip into it. Okay. What do we actually mean by water ingress then, Frank? What does that mean?
Water coming into my unit. So from an outside source. So clearly, well, not clearly, can come from an inside source as well. But the typical one is water through the roof, water through windowsills, water into basements. new builds. Water leaks through from planter boxes upstairs, from podium levels onto things down below. And it can come from anywhere, really. And I suppose this is the thing. My father used to be an insurance loss adjuster. So the sort of guy that goes out and looks at insurance claims. So when there's a claim for water, part of it always is, where does it come from? And he always said, never have a flat roof, because water will always find a way to leak downstairs. And I think lots of buildings have flat roofs, but there you go. So it can be rain, it can be leaking pipes, can be hoses, can be burst pipes internally, can't it? We get a lot of that in high rises.
Those flexi pipes, Frank, I remember going to a seminar by an insurance colleague of mine who, I can't remember the figure cited, but those flexi pipes, first of all, there's a misunderstanding about how long they last for. People think they last a lot longer than they do. And then secondly, you've got to think of it. If that bursts and you're away for the weekend, and you happen to be on a high floor, that's a nightmare scenario, but it happens. I think it's the most claimed about insurable event in Strata, I believe.
Someone told me that anecdotally the other day, and it might be the same person, I don't know.
Yes.
But yeah, yep. And I've certainly had enough random, immediate inquiries about it, where pipes are burst, owners are away, floors are flooding, going downstairs, out. What do we do? Which gets a bit messy too. But
so, like you said, yeah, absolutely. Like you said, Frank, it could be rain. So these days we call it a rain bomb or a rain event, all of that sort of stuff. Could be something like a flood, but I think important here, Frank, to clarify that when we speak about flood, we need to be very careful about terminology, don't we?
We do, because insurance is a massive issue at the moment. Water damage and water damage caused by flood, and this is as close as I get to being an insurance lawyer. The policy terms and conditions are really, really, really important. So, and that's, I come back to 2011, the floods then, there was arguments about, I remember one in particular, where as underground pipes backfilled and sort of water burst up through the pipes, was that caused damage. Was flood the cause of that, or was it bad pipes and a heap of rain that was the cause of that? So you get into all those sort of messy arguments, but still led to water damage. And I suppose part of this too is, and this is one of the messy things we get into all the time, is a body corporate might look to say, an owner occupier, someone drives into a pipe, causes damage, floods, whatever. Like from a liability perspective, you probably look at that and say that's relatively simple in terms of who's responsible for it. But when it comes to insurance, claiming on insurance is one thing. The statutory obligation to maintain common property in good repair and condition is another. And they're not necessarily consecutive. You don't do one, you don't make the claim on insurance and have the insurer pay and then do the work. From a statutory perspective, the body corporate's got to do what it's got to do. And if it has the right to recover from a third party, be that the insurer or be that the occupier that caused the damage, then it goes and does that separately. Doesn't wait for one to do the other.
Really good point, Frank. That sometimes gets overlooked. Yeah, it does. You mentioned there sometimes water ingress is as the result of an event or somebody causing something. Something as simple as an overflowing bath. It might be also as a consequence of somebody doing work inside their lot, and particularly renovations to, say, bathrooms or anywhere where there's a sink. That might be another issue as well. I guess ingress too, Frank, you just highlighted it there. It might be an immediate issue, or it might be something which develops over a period of time.
Slowly creeping up on it and drives people to distraction. And those are usually the ones that are the messier disputes.
Absolutely. Absolutely. I think we're both familiar with those. Well, then it always leads invariably to the next question, who's responsible? And
I suppose this is where the legal stuff starts, isn't it?
Yes.
Because we've got really two different types of plan format that govern strata in Queensland: building format or building units plans, and standard format or group titles plans. So generally, and this is the danger with these things, there are no hard and fast rules. So you would normally think, so every high rise is going to be a building format plan. That's the reality of it. So they're all, boundaries in there. Standard format or group title plans are usually townhouse estates. villas that might be side by side or standalone separate lots or whatever it might be. But surprisingly enough, some of those townhouse estates can be building format plans. And sometimes, even more messily, if they were built over stages, and I know one building in particular that has this, first stage was standard format, second stage was building format. Next stage was standard format, next stage was building format. So you can have a mix of plan types inside the one body corporate. And that's why I think back to the start, and I suppose, mate, for me, these are trying to give people answers that hopefully they don't need legal advice on. But I keep coming back to these things can be tricky. And that's a simple reason why. Because even then, sometimes people just don't understand the different type of plan format.
Or that there is a plan.
Yes.
Or I think, Frank, for me, it's really just a start point, that one.
Yes.
So the question, who's responsible? The first answer is, well, it starts with what's your plan of subdivision? So that's where it starts. That's all it is, though, because then it's the next layer of all of those things that we talked about before, and a few more things that we're going to talk about right now. Because for me, I think once you have that start point, the next thing is, well, it's a matter of cause. What's happening and why is it happening?
Yep, absolutely. And it's very easy to say, I have water coming in my roof. I get it. So, and in a building format plan, I'd say 99 times out of 100, that is going to be a body corporate problem, because it's a piece of roofing infrastructure providing protection, which from a legal perspective is a body corporate issue. Done, sorted, happy days. There can be carve-outs though. So again, the very rare ones, but for that one, that's almost certainly going to be a body corporate issue. But why is that water coming in? So the water is appearing, and this is the issue that I suppose we get all the time, is we have people pointing fingers at each other. The owner is saying to the body corporate, fix it. And the body corporate is saying, well, before we fix it and assume responsibility for it, we need to know why. And I suppose, Chris, an example of a carve-out is where the leak or the ingress might be caused by something the owner has done on the roof space of that particular lot. Maybe they put a spa in, maybe they put a satellite in or something like that. So if an owner has improved or built something on common property, that can then make the issues that flow, pardon the pun, from that installation their responsibility, not necessarily a body corporate one.
The flip side of that, though, then, Frank, of course, is going back to your comment about being reasonable. It might, all of that you just said might appear very logical and straightforward, and well, this is how it's got to be. Except that from the body corporate's perspective, being reasonable goes both ways. So it's being reasonable in fulfilling responsibility, but it's also being reasonable in about not fulfilling responsibility as well. So is it reasonable for the body corporate to take the time and the effort and the steps to consider if they actually should be assuming the responsibility in that case? Of course it's reasonable that they do that.
I think so. And certainly, historically, one of the biggest issues we have with those sort of advices is where's the authority or where's the consent to that particular approval? Because if it happened yesterday, then we might have terms and conditions around it in the minutes and whatever it might be. We might have an application from a lot owner. We might have the body corporate in writing saying, yes, this is the basis on which you're allowed to do it. The difficulty is when it happened 15 years ago and there are no records. And to the extent there was even a conversation at the time, perhaps the owner just went and did it. And the lot's been sold twice subsequently. And now, and this is on, and I know this because this is exactly what's happening for a client of us at the moment. A client of us, good English, Frank, a client of ours at the moment, where water is coming through the roof, and there has been an exclusive use area that's been improved, and it happened forever ago. So we don't know, acting for the body corporate, what the legal position is in terms of what were the conditions of any approval that were given.
That's
so from
right.
a body corporate perspective, you've got to be so careful.
And then, of course, you've got the situation, well, let's just say, picking up on your example, Frank, so stuff has happened over a period of time and works have been done. So does that mean that those works now have to be completely undone? What's involved in that? In some cases, that would be massive undertaking.
What's just and equitable?
That's
Here we
right.
go. Yeah,
So
and you're having these,
that's that. Yeah. And then you might have a situation where the works are actually in progress. And so, okay, do we stop? Okay, even if we did stop, then how does it get restarted? It can't just sit there indefinitely. Something needs to happen in that scenario. But striking the balance in those scenarios, Frank, as you say, without either legal advice or a proper consideration of the issues, it's very easy to find yourself off on a path that's not helpful for anybody in the situation.
Because the moment you go denial, let's say from a body corporate perspective, nope, that's your problem. Instantaneously, everyone's backs are up. So I think, if you're back to what is acting reasonably from a body corporate perspective, it's investigating what has been put to it.
Yep.
To the greatest possible degree. What happened? How was this approved? Do we have these things? It's not a matter of demanding things of that particular lot. I'm saying, do you have records relating to what might council have? All that sort of stuff to get to, hopefully, what an answer might be.
And then, of course, Frank, there's the very practical and very real issue of getting the necessary evidence to support all of that. In order to get that necessary evidence, you're going to need someone with expertise, engineer, plumber, all the rest of it. They're very thin on the ground these days, and their willingness to pick up the phone and even quote, let alone do work, is it's a massive issue for strata schemes at the moment, and
that takes time. And when there's rain coming and the roof continues to leak, and it's been going on for 2 years, everyone's gets a little bit more frazzled by the day.
Absolutely, they do. So I it's very easy for us to sit here and say patience, but there is a process that needs to be worked through. Let's try, Frank, maybe a couple of relatively simple examples to sort of work through this kind of thing. So in the building format plan, we're talking about things like flashing, skylights, perished silicon gutters. That's typically going to be body corporate, isn't it?
It is, subject to those carve-outs we got for. No, if it's a completely vanilla roof, always been that way, it's a building format plan, then almost certainly it's going to be a body corporate issue.
Except though, what about if the owner has done something to the roof, Frank?
Well, there we go. They installed the skylight, which in theory should be, well, the roof is common property. Was there an approval for that? What's the conditions of the approval?
Solar panels. That's an interesting one, isn't it? Because there are some pretty specific laws about solar panel installation in Queensland, I think in most states and territories for that matter. So on the one hand, you've got that, but then on the other hand, what if that installation has in some way contributed? Who knows? And maybe one of the tradies who was doing the solar installation, Frank, dropped a hammer,
punched a hole in a roof, and caused a weakness that has subsequently turned into rust and leaked.
Right. Okay. I mean, on the one hand, you were quite obviously permitted to install the solar installation, but what about the rest of it that's happened there? What about standard format plan, Frank? Let's mix it up.
Absolutely. Well, and again, so mate, checking what our plan is. I suppose where I get to, like, one of the rules, and this isn't absolute like all these things, one of the things I always sort of come back to from talking to clients about it is, in a strata context, if I choose not to maintain my lot or not to do something for my lot, so I've got a statutory obligation to keep my lot in good repair and condition, but that's up to me. Body corporates might have to go and force that at some stage. But if my activity or non-activity, as the case may be, causes impact on other people. So if I don't maintain my gutters, and it turns out that gutter is, as much as it might be on my standard format lot, but it's shared, the infrastructure is shared with 2 other lots because we've got an adjoining wall somewhere, then, and I don't do something that affects other people, then it can become a body corporate issue. In the sense of the body corporate gets to step in and do something about it. So that can be across the board on roofs. So if I'm in a standalone villa on my own 400 square meters of land, I've got nothing else touching me, then almost certainly in a standard format plan, the roof's going to be my problem. If we're sharing roof issues, then you get to those shades of grey about what happens if I don't do what I should be doing.
Absolutely. What about in a courtyard or private yard, Frank?
Well, I suppose it's sort of, again, is this on title or is it exclusive use? Because again, this is this building format plans. So these townhouse villas that are on building format plans, their courtyards might be exclusive use. So then you get into the conversation around, the default position from a grant of exclusive use under the Act is that the owner is obliged to deal with the operational costs and maintenance of that area. So that goes without saying. Now that can be carved out, that can be left as the responsibility of the body corporate if the bylaw says so. But if the bylaw says nothing, it's an owner's problem. So courtyard issues in both standard format when you own the land or in exclusive grant of exclusive use can become owners' issues. And again, I suppose then you're going down. So we've got a pipe. We've got water that's coming up through the drainage in the courtyard area itself. What's the cause of that? Is that because the body corporate hasn't done something 3 doors down or has let, an owner's tree in their courtyard 3 doors down? So the tree maintenance is going to be an individual owner's problem. But is someone else's tree's roots growing into the infrastructure that's causing the blockage that is now causing the water to backflow up into my courtyard, which on its own might be my problem, but there's a cause down here that is someone else's.
And what if that tree is actually on the property of a totally different but neighbouring community title scheme? And so let's end. The owner has let the body corporate know about the problems with that tree a couple of times over the last few months.
Well, this is the Neighbourhood Disputes Act. So it used to be, I think, the tree keepers something or other, now neighbourhood disputes in terms of trees that cause damage. So be it a neighbouring body corporate or a neighbouring lot, whatever it is, there's a process to follow in relation to that should have been done. So, and then you go, I suppose if the owner has put the body corporate on notice and the body corporate's the one that has the rights with respect to the neighbouring property and the body corporate has done nothing, could they have done something that would have prevented that damage? So that's all I suppose in theory, that's sort of partial negligence, duty of care owed, duty of breach, duty of care breached, loss and damage resulting. Bloody
especially
messy
if there was
from a legal perspective.
Yeah, especially if there was a motion put up about it, Frank. No, approach neighbours, re-tree, and committee went, nah, can't be bothered.
And we're now back to owners' motions to committee meetings, aren't we? 6 in 12 months, away you go. There's one way to get it on the record rather than send a letter.
We haven't even begun to scratch the surface of some of these specifics, so a lot of this will get held over for a sequel. Just want to touch upon this idea about being proactive, though, Frank. So we've spoken about this a few times, and people speak about it all the time, this idea that if we're proactive about maintenance and our responsibilities, whether we are an owner or a body corporate, then that's our best chance of getting decent results when it comes to water ingress or preventing the water ingress.
So that's going to go away.
No, that's right. But that's fine. But what happens where an owner or a committee is just not up for that challenge, Frank?
This is the difficulty of the world in which we live in Strata, which is run by volunteers. And the government's never going to make it anything other than volunteers, and I get that, and people should be in control of their own destinies. But just sort of looking at some of the recent adjudications, it's quite clear adjudicators are saying to committees, when you put your hand up to get involved, that involves doing things, not simply ignoring things. So as much as, personal liability, I think, is unlikely. You never know. Might get a little slap from an adjudication perspective at some time, but I think more than anything else, it's when you put your hand up to be on a committee, sticking your head in the sand and hoping stuff goes away is not the appropriate way to deal with things.
Yeah.
That's the reality of it. And that, if you're not willing to do that from time to time, then really you should be resigning from the committee and make it someone else's job.
Yeah, I think so too.
As brutal as that might be, mate. I get it. I understand what comes with volunteering. I'm on a couple of volunteer things myself, not a body corporate, but that's what people have to do when they put their hands up.
The flip side of that, though, is to remember that from the owner perspective, there are set timeframes for both committee and body corporate. There are different thresholds of decision making, and all of those decisions are subject to potential challenge as well. And then there's the reasonableness overlaid on the top of that with body corporate must act reasonably, which might mean taking a bit of time and a bit of effort to get to those outcomes. So I think, Frank, it's a process. Well, actually, before that, it's about steeling oneself for it.
Yep.
This is going to take effort. I need to be resilient, whether you are a committee or an owner. I need to be resilient. If I want this seen through, it's likely it's going to require a bit of effort on my part. Deep breath, then engage with the process.
And dare I say it, lay off to other people that can give you the right advice so that the grunt work is done by them. So what's our legal position here? Well, here it is. And I get it. People don't want to spend money on lawyers, but then what happens is you end up in the commissioner's office having a blue and no one's got any expert advice about what the cause of this thing actually might be. Drives adjudicators nuts, and that's going to take more time.
Yep. In the very short time we have left, Frank, do you just want to touch upon this idea of minimum housing standards and water ingress?
Yes, webinar on this for minimum housing standards. Ladies and gentlemen, we did a little while ago, I don't know, maybe 5-6 webinars ago. So what is coming in October 2023 is a bunch of minimum housing standards really to protect tenants that landlords are going to have to provide. And dead set, we haven't seen what they are yet, but with as much as both of us, as sure as both of us are here talking to you today and you're listening to it, it will relate to protection of people from mold and water ingress in their real estate, in their units. So that's going to be as equally to houses and landlords, and it's absolutely going to apply to bodies corporate. So from a body corporate perspective, what we're absolutely going to have is tenants having rights with respect to water ingress into their unit, potentially against their landlord. But also then, and this is the difficulty that's going to come with Strata, is landlords can't necessarily control or deal with addressing that concern. So from a body corporate perspective, we are going to see demands starting to fly when tenants start to exercise their rights, assuming they relate to water ingress, which they almost certainly will, in relation to body corporate issues. Yeah. So again, there's a window now to sort that stuff out from a committee perspective and from a lot owner perspective if you're a landlord. So if there are water issues, now's the time to get ahead of it while you're still in control of the timeframes and probably the consequences.
Absolutely, Frank. Just a preview for our sequel on this one. I think we're going to probably have a look at some window and door issues.
Balconies.
Always a good one. Balconies. We touched a little bit upon that today, but there's a lot more to go with balconies. And one of the really common issues that comes up here with water ingress is this idea of damages, loss, and how that gets treated. And I can assure you that is far from simple, that kind of stuff. Far from simple. So that's just a bit of a preview of coming attractions. But for now, that's all we have time for. You can find all the notes and links that you've mentioned. You can also find Frank at hindslegal.com.au. He's sitting by the phone, absolutely eager for your call. You can find me. I'm probably just as eager, I suspect. Maybe. No, I am. At stratasolve.com.au. Until next time, whether that be the sequel to this or an entirely different topic. Frank, it's been a pleasure.
Always, mate. Thank you, everyone.
Thanks, everyone. Much appreciated.
Bye.
Bye-bye. Far from simple, that kind of stuff. Far from simple. So that's just a bit of a preview of coming attractions. But for now, that's all we have time for.